Meet Sylvia Ho, a lawyer who's got the legal info that business people need to know.
Hello, everyone. Welcome to my office. Today, we are going to talk about copyrights and trademark and doing business on the internet. Everybody seems to be doing a lot of business on the internet, and it seems a little bit like the Wild West. I have a lot of questions from clients. My clients are small business owners, but today we have an attorney who serves both small and large businesses in the area of trademark and copyright. And we're going to talk to Jamie Sternberg from Saunders and Silverstein. Welcome, Jamie.
Thank you for having me, Sylvia.
What I like to do is talk about just generally in general terms about copyright, trademarks, and brands. I get a lot of questions, and I have clients who have had different issues. One of the biggest issues that they have, let me start off with, is they have a brand. They've developed the brand. It's pretty strong for our local area, and maybe we're moving into other states like Massachusetts, where I understand you and I both practice in Massachusetts as well, right?
Yep, Connecticut and Mass.
And they go along, and someone has taken their brand and made it a searchable term for their company, so that the consumer that's looking for my client's business is ending up in some other business's website, and they're going to that address. And in our world, that's unfair competition. And the way that unfair competition is being perpetrated is through the internet and through violations of that trademark. So let's talk about Google search terms.
Sure.
Does this happen often? And what can you do about it?
This happens all the time. And there is a black and white Google policy about it. Google will allow competitors or someone who wants to use a trademark of another company as a keyword search term. They can do that. They can buy those terms. And when those terms are put in by consumers, then it will come up to the sponsored ad of the competitor. So a competitor will use that search term to get their sponsored ad to come up. Google will not stop the use of the keywords in that way. In fact, they will probably try to sell you your competitors' keywords. And in some industries, it's common for competitors to buy other competitors' trademarks as their keywords to have their sponsored ads come up. So I would, if you're thinking about doing that as a business owner, I would certainly talk to a lawyer about it, because so Google won't do anything about it. And then the circuit courts are split on this issue. Like, for example, the Second Circuit, which encompasses Connecticut, I know they haven't been favorable to cases where it's a case against two competitors rather than a company against Google. They haven't been too favorable to plaintiffs in a case like that, because there's a question on whether the use of the keyword to come up with these sponsored ads is considered use in commerce, which is one of the necessary elements of a trademark infringement claim. In the Ninth Circuit, they've been more favorable to cases on this issue. Now, cases that companies raise against Google on this issue, Google has, for the most part, won those cases. But so what is impermissible, and this is also black and white policy that Google has, is that you can't use a competitor's trademark in your sponsored ad text. And so Google will take down sponsored ads that have competitors' trademarks in sponsored ad text. You can use the Google registry to register your trademarks and let Google know who's authorized to use your trademarks in sponsored ad text. because sometimes companies have licensees or resellers that are permitted to use their trademarks in sponsored ad text. You can sort of forewarn Google about that. You could also say to Google that you are the only company authorized to use your own trademarks in sponsored ad text.
So in short, if it's a search term, Google makes money off of it, but Google will not allow you to do what? That's blatant infringement, to put the name of company A on the site of company B, so that you would, I
In
would,
this,
I would guess that in terms of unfair competition law, right, that would create confusion, and
not,
that blatantly will do that.
Google won't allow one company to use another company's trademark in their sponsored ad text. So if you buy, if Coca-Cola, for example, buys Pepsi as a keyword to put into a browser, and then, which is permissible under Google policies, and then Coca-Cola uses Pepsi, because when consumers put the keywords into a browser, sponsored ads come up. That's why companies are buying these words as keywords, because they want sponsored ads at the top of the page to come up. So if Coca-Cola buys Pepsi's name as a keyword and then uses Pepsi in the sponsored ad text that results from that search, that sponsored ad can be taken down.
Well, since we're using two competitors' names, let me just move a little farther down on my ad. Suppose I compare my product to my competitor's product, and I use their name, and their name is trademarked. Would that be what, a fair use, or is that possible that I can do that?
Yes,
I
I
think
mean, you
that's what
can
my clients would want.
buy, yeah, sure. You can buy a competitor's trademark to have your sponsored ad come up. If your sponsored ad doesn't include your competitor's mark, consumers can go to your webpage. And yes, I mean, there can be comparative advertising. Comparative advertising using your competitor's trademark is fair use, as long as you're not using more of the trademark than you need to use. For example, like if you start using your competitor's logo, when you could just use the standard character mark, that can be considered crossing the line.
That's a very expensive way to find out whether it's crossing a line or not. I mean, with the large companies, that's a easy thing, because you have like a whole, army of lawyers that are ready to come and argue either side. But what can a small business do to basically compare themselves with their competitors, other than by the search term? That's a very clever kind of thing to do for
And
a certain time limit. But what else what else is within the confines of possibility to compete fairly and within the rules of Google without infringing on that trademark?
well, just to clarify, I mean, if you're buying your competitor's trademark as a search term and then getting consumers to click on your sponsored ad to compare products, while both of those individually may be considered fair use, that together could
May not be.
potentially be an unfair competition claim. But in terms of comparative advertising in general using Google, I mean, yeah, I think that it would be interesting to look to see if that whole scenario would be considered fair use.
Let's just talk about the issue of fair use, because I
Yeah,
think
sure.
that's a term of art that a lot of business people don't really understand. Like, as lawyers, you and I can have that conversation. If I had a client and we were in the middle of a very tough fight in competition, oftentimes these competition issues are beyond the intellectual property and of the brand rights of the client. They also involve a lot of other activity that are outside of that. But fair use is a term that is used in intellectual property and also in copyright. Can you briefly describe what fair use is to your normal business person?
Sure. So in terms of trademark, fair use would be, it would be considered fair use if, for example, a news outlet like CNN um, or the Associated Press is talking about a specific company and the article is about that company. They can reference, they can use that company's trademarks in the article. Um, if you're talking about a company, for example, I have trademark presentations that I give, and I use logos from other companies in the presentation. I use trademarks, but it's for an educational purpose. I'm not using those marks to sell a competing product or service. That would be considered trademark infringement. Another example of fair use is the competitive advertising that we talked about. Competitors are able to do that. They compare because they're comparing. That's the only way to refer to their competition sometimes is by using their trademark. Sometimes companies try to go around it by saying, oh, the other soft drink company or something like that. Or, companies try to use the Super Bowl, for example, when they're trying to capitalize off of marketing a good or service related to the Super Bowl, and the owner of that trademark doesn't like that. So companies have to say the big game because they're trying to sell products or services and capitalize on that Super Bowl trademark.
Yeah,
Whereas if a sportscaster is talking about the Super Bowl or writing about it, they can say Super Bowl because they're not trying to sell their good or service in
right,
connection
right,
with that.
right.
So that's really the thing to think about. Are you using the trademark in a way that's the only way that you can talk about a company? Then you would use the brand name and keep it to the brand name, not to the logo. If you're trying to sell a good or a service in connection and capitalizing off of the goodwill developed in that trademark by a competitor, you want to think about, whether that use would be an infringement or fair use.
It's funny when you say that because beyond the issues of intellectual property, you can get to the point where you're doing unfair advertising, and that's another form of unfair competition. I mean, this whole area brushes up against unfair competition all the time. Those claims are brought side by side.
Oh, yes.
Um,
Yeah.
so one thing that also happens is I make a website
Yes.
and I put tens of thousands of dollars into it, and someone comes by, a competitor, maybe not a competitor from another state, and copies my into all the code of the website. Now, I have not registered every single page. What can be done about that? Is that an infringement? And I think that the answer is obvious, but why don't you speak to that? And what can
So,
be done?
yeah, I mean, the first thing you want to look at, though, when you're thinking about an infringement claim is who owns the rights to the website, who owns the rights to the code, who owns the rights to the content on the website. If, let's just say, the business owner has had all these rights assigned to it, which you want to make sure you do if you hire a web developer to help you. You want to make sure that you have rights to the code and the content on your website.
You want to add that to your contract, which
Yeah.
rarely, if ever, any business owner ever
And
includes.
that is the first thing they should think about. um, but in terms of the code, I mean, sometimes parts of code are not copyrightable by the owner of the website because it's standard code that everyone uses to
Right,
develop websites. So
right,
obviously that wouldn't be at issue. And if
right,
someone were to take that, that's fine. That's fair use, right?
right,
Like open source code.
right,
So that would be fair use in the copyright context.
right.
Now, so let's just say the business owner has the rights, and if you're looking at an infringement claim, if they don't have the rights, maybe they want to get that in order before sending a demand letter, so we kind of know, we're on the same page as the potential copyright owner. But so you can send a demand letter to this other company. You can send it if they've copied the whole website. There's copyright infringement claims based on the code, based on photographs that are on the website, potentially blog posts, content, trademarks? Did they copy the brand names? There could be a lot of claims that you could raise. And
It's kind of common. I mean, I've run across the situation 3 times already, in the last
yes,
2 years.
I have too. And in one particular case, our client had a database of restaurants in a particular field, and another website was stealing from that database. Now, the compilation of that data is copyrightable. And we filed the application for this copyrightable work before we sent the demand letter. Because at that time, I believe, you could proceed in court with just a copyright application on file. And of course, your what's called common law copyrights, which you have upon the creation of a copyrightable work.
Right.
Um,
It
but
actually gives
now,
you the right to file a claim under the Copyright Act, right?
yes, no,
No,
not until you have the registration, because
right,
there was a circuit court split regarding that. You needed at least an application on file in certain circuits, federal circuit courts, or you needed the actual registration. And I believe it was last year that the Supreme Court dealt
right.
with this split and determined that you need to have that copyright registration. So it is important to think about that for a small business owner, because the investment in a copyright application is so much smaller than having to get an expedited registration if you learn that someone's infringing your rights. The government fees for an expedited copyright application are $800. Those are just the government fees. Whereas if you do the copyright application yourself, it's like $45 to $65, depending on the type of application it is. And that's the government fee. And if you have a lawyer help you, then it's like probably between $300 to $1,000, depending on the issues. So that's a lot less expensive than what you're going to have if you learn someone infringes your site and you don't have that registration when you need to have it. You can still send a demand letter, but if they have an IP lawyer, the first thing they're going to ask you for is to see a copy of your copyright registration, so they can know how far you could actually bring this claim.
This is a very interesting thing for creative companies that do things like make websites, do little, app developers, groups like that, because those repeatable types of business, as opposed to, your Main Street business that has one single website, those repeatable types of business could create from the source code something that is original that they can resell over and over. So if you're a web developer, that's something that you might consider copywriting the code of what you do to a particular industry. And because you're going to be selling that template to them, and it's going to have some value to you, because you're not just selling one of, right? You could be selling 10 a day in
Exactly.
those. So that's worth the investment there.
Yes.
So I think in terms of, let me go, one more question for you. And because I know you have to go.
No, we have plenty of time.
The question is international business. Now there's suppose you create a brand. Now sometimes these brands are they're statewide if you're a small company and you only have, say, a license. Let me just backtrack. If someone violates your copyright, why not make lemonade out of lemons, right? Other than cease and desist. I think a lot of business owners are thinking, well, all right, so they copied something. They're not anywhere near me. It's going to cost me something to hire a lawyer to get them a cease and desist. Why not make lemonades out of lemons, right?
Right.
And we could do that by asking them for to pay you the fees, and then
The
to
royalty
license.
fees. Right.
Yeah, and to license what they've copied to them, assuming that they don't want to rebuild from square one again, right? Because all their data is probably in there, or they're using
Yeah,
your
if
stuff.
that's something that the copyright owner can live with, then that's certainly a way that that kind of case can be resolved in a less expensive way than having to file an expedited copyright application and litigating. And let me just stress that if you file in a copyright application on the normal turnaround basis, it can take months. So that other website could be up infringing your rights for months. I mean, if you don't have a trademark claim, also to on that basis to maybe take it down, or you could potentially take it down on a unfair competition claim. But I had a client who another client actually with a database, an animal database, um, getting hijacked by another company, and they wanted to allege copyright infringement as part of the complaint, and they had other claims, but they couldn't include it until that copyright application became registered. And in that case, we filed an expedited one and had it within less than a week, whereas
Oh,
like the
really?
regular application turnaround can
Wow.
take months.
Yeah. So
So,
there's an expedited process.
and I think it was partially really fast in this case because at that time it was like maybe May, so it was during the pandemic. They're only sending out electronic registration certificates. So literally, we just got the certificate and they were ready to go.
That's good that you can add to the value and to the claim by the speed. I think a lot of intellectual property has to do with timing. And so here's something let's talk about international and EU. Obviously, there's a lot of actors, cyber criminals. They're from other countries. They copy code, they hijack your website. But what kind of enforcement mechanisms for American copyright rights are there internationally?
I would have to consult with lawyers, local counsel in the particular country at issue to kind of see what the best strategy would be. Um, but I mean, the first thing you could do is just base it on your US rights if that infringer's website, for example, if it's a website is available in the US. So that's probably where I may start there.
Block it from coming into the United States.
I would just ask for it to be taken down fully,
Mm-hmm.
as I usually do with any website where there's infringement.
Mm-hmm.
And if there's pushback, then yeah, I mean, you may have to consult with local counsel to get a sort of more specific result.
I think as a small business owner, and I'm small in the sense that it's closely held and not really operating at this, Fortune 50 level of business, it's very frustrating. I think there's the possibility of doing business nationally and internationally, but on the other hand, there are all these costs as well. Is there some practical effect? I mean, other than, now you've worked on this website, and some bad actor from outside of the country is infringing, and the only choices are pay a ton of money for a lawyer in that other country, which you don't know what the other country is. They may have no treaties, or start all over again. It could be quite unsatisfying and sad. Do you
Well,
have any
that's why I
suggestions?
would start. Yeah, I mean, that's why I would start basing it on, like, if the website's available in the US, just have your US attorney, or a business owner, can just send a letter. But I think it's better coming from
An attorney.
an attorney, asking the website be taken down. And but if it's a specific country where a lot of people don't speak English, you're going to want to have a local attorney who sends a letter in the demand letter in the local language. Because if they get something in English and they can't understand it, that's not really going to be useful. So I think it's really based on the facts of this particular situation, what the infringement is. Can a US attorney handle it? Can the business owner handle it directly? Do you need local counsel? I can't, give a that's my answer without sort of knowing the specific facts.
That's very,
That's a very lawyer answer, I
yeah,
know,
it's
but
it's also very unsatisfying if you put
well,
all this money into it. I mean, I think one of the things that happens, let me just see, what about domain names? So you have this great business, and then you go and you find that someone else has bought the domain name
mhm.
and is asking you to pay $50,000. I'm just thinking about this because this has happened. Asks you to pay $50,000 for it, so you even have a choice of paying $50,000 or choosing another domain name. And then the other scenario where you've incorporated and you've registered your trademark, and then somebody finds out about it and then goes and snags that domain name.
Mhm.
So those two instances, can you speak to that?
So in the first instance, I'm assuming that you're just thinking about adopting a particular trademark and you're looking to see what domain names are available.
Yes.
So in that case, the number one thing, first of all, I would say is do not invest a significant amount of money in a domain name until you or your trademark attorney have done a search to make sure that your brand name is available. Because I have had clients in the past buy domain names, spend thousands of dollars, and then we realize the brand name that they want, that they've made as part of their domain name that they registered, isn't available.
Right.
And then they have to keep registering more domain names. So do the trademark search first. If you've done that search and you realize that your brandname.com, for example, has already been taken, there are services you can use to maybe make the process less expensive. Like if, first of all, you could maybe make an anonymous request to buy the domain name, or you can use a service so that the price of that domain name, there isn't like they don't ask you like a premium price, for example, because they know that you don't have a business, they don't know about your business, for example, that maybe you started before buying the domain name. So those are, do you have to pay $50,000? I mean, no, there's other domain name extensions that you can choose. I would make sure that the person using the domain name or who owns the domain name that you want doesn't have a business with a similar name as you for the similar goods or services, because then you could be considered infringing
Right.
their mark.
That's
If
part of the trademark search. One of the things that happens is, we all know this, it's less public now because it's given. There are cyber squatters out there. Well, take every single thing. I mean, I get emails going, well, do you want, Connecticut business lawyer? I got it. I want to sell it to you. If you could, could you
Right.
use that? I'd let go some domain names, and then I got an email back going, you let go this domain name. Do you want it back? I'm going to charge you more money for
Right,
it. So
exactly.
there are people who game the system like that.
Yeah, I
Um,
mean, I represented for a very long time in the internet and domain name enforcement program a company with a famous trademark. So their trademark would get purchased by cyber squatters all the time in what's called like typo squatting, so spelling their brand name, the famous brand name, in a way that maybe a consumer would type it into a browser,
right,
or using their brand name with a descriptive word that has to do with their industry.
right,
So in those cases, you have to look at the facts of the situation and how much contact information you have for the person who registered the domain name. In some situations, maybe it's someone who's innocent, a small business owner in the US. Maybe I could just give them a call and resolve it that way. Or I could send them, or you could have the option of sending a demand letter. If it's someone in another country, you may have limited contact information. And you could try to, we'd always start with a letter first, because that's the, least amount of money that you could put in to enforcing.
right.
If it's something that's very like the brand name of the client with a term that is very, descriptive for the type of industry, and and the goods or services it's parked on a page with links to your competitor, or it's parked on a page with competitive goods or services, and they're not responding, or you can't find contact information and you need to get it down, then you can file a uniform domain name dispute resolution. I always get the last word wrong.
Is that in Virginia? Is that where that?
Proceeding.
It's like,
Policy proceeding, yes.
oh,
Uniform domain name dispute resolution policy, or
Yeah.
proceeding under that. That you can be anywhere in the country. It's an administrative proceeding where you have a panel, 1 to 3 panelists from, and usually the arbitration forums that people use for these are the World Intellectual Property Organization or the National Arbitration Forum. If the extension of the domain name is like a .country extension, like a .cn or a .ru, then you need to consult with local counsel in those countries to see what the domain name takedown procedures are for that extension. Because sometimes you can't do UDRP, and sometimes you have to do court litigation in some countries for extensions like that.
It's all very expensive for a small business owner.
Well, the fee for 1 to 3 domain names for a UDRP is about $1,300. And that's just for the administrative panel. And then usually for the attorney to prepare the complaint to be filed is maybe between like $2,000 and $4,000. But it could be less than, like, for example, if someone has a domain name you want and they're asking for it for like $25,000, you can do a UDRP for much less and not give that person the money. And you can get that infringing domain name transferred to you in a UDRP action. So, and if you're looking at the whole of things, like settling for a higher amount or possibly going to court, a UDRP is actually the least expensive way to do it if a demand letter doesn't work.
I think that becomes, a cost benefit analysis all the time, just like in business, everything is a cost benefit analysis. I mean, in a lot of ways, unless it's a tested and proven brand, it probably is better to make those changes. So like everything else I think in IP, you need to do it at the beginning and figure everything out. It's cheaper to file than it is to deal with infringement, right?
Yeah, like do this, but you can't register every single domain name that you could possibly have with your brand name, obviously, right? So you want to register the primary ones for your house mark, and then the primary domain names for your your primary products or services, if you call them a different name. But you can't register your brand name in every country with every country code.
Oh, no.
So yes, it's a cost benefit analysis.
Yeah.
If you send them a demand letter and say, take the website down, they take the website down. You don't need to have the domain name transferred to you. You can just monitor it. If they start using again, send them another letter.
Right. What would you recommend people doing to monitor their brand, to make sure that they're in control of it, and especially if they're a growing company?
You want to have some kind of watch service. So there's watch services to see what kind of trademarks are getting filed with the US Patent and Trademark Office or intellectual properties offices all over the world. So you can do trademark watch services. There's also domain name watch services. And there's also watch services like internet watch services. So you can see how your mark is being used on social media platforms, for example. So you want to take a look at your business, talk to your lawyer, and maybe think about the best strategy in terms of watch services, which aren't really that much in an annual fee. They're pretty inexpensive.
Right.
And I, for example, you'll only see a bill from me if I'm looking at a huge number of watch notices, like maybe I look at it once a month or something, or I'm reporting a specific watch notice to you that looks like it's concerning. Otherwise, I just kind of take a look at these quickly every month as they come through.
I think that it sounds like pretty overwhelming for your business. owner, but it depends on the product that you have, right?
Right.
It depends on also what the value of that product is. That if you're not just the domain names, but if your trademark is something that is a high-tech product, you want to make sure that that doesn't get out of hand and it doesn't go to a secondary country
Right.
somewhere else that's manufacturing a fake or something else, then you could really get out of control. So I thank you for doing that. I just wanted to put it in the context with somebody who's not a lawyer and trying to figure out, wait, how does that, if I'm paying for this watch service, what does it mean? But if you have a very high tech precision product and you're building that product for certain industries or a wide use in industries, you have to really think about the entire package, from the patent to the trademark to the copyright to your domain name, to make sure that all those things are protected, because once you put that in the stream of commerce, you're asking for competition. So
Yes.
thank you very much, Jamie. It's been
You're
a very
welcome.
interesting lawyerly talk. And if people want to get in touch with Jamie, I'm going to put her information right below. And some of these watch services, I think we'll put that information below as well. Thank you
Okay, sounds
for
good.
appearing. And we're now on my domain, so, or
Right.
soon. Anyway,
Thank you. Thank you for
thanks.
your
Bye-bye.
time. Bye.
Do